Hey everybody, good afternoon. Welcome to our webinar. This is the latest in our webinar series on organizational conflicts of interest. We're going to go through a number of things, but first, just to introduce ourselves, my name is Alba. I'm a partner at the Government Contracts Group here at Plero Mazza, and I'm here with my colleague,
Michelle Litteken, an associate in the Government Contracts Group.
And we've dealt with a number of OCI issues recently and in the past. And so we thought it would be a good time to do a little refresher for people or for individuals who don't have a deep knowledge of OCI of issues and how to mitigate things. We thought it would be a good time to come up, given that contracts are being awarded and new fiscal year and whatnot. So welcome to everyone. For those who don't know, Plero Mazza is a small, almost mid-sized law firm now. We have about 20 lawyers, and most of the lawyers here do government contracts. We also do labor and employment work. We do general corporate work, M&A, and also litigation for the unfortunate times when that happens to occur. So just really quickly, we did have a question about the link to the slides, and apparently when you click on the link, the last webinar on contract terminations pops up. I believe that's because we haven't posted these slides yet, but we can do that right now. Otherwise, they'll be posted right after the webinar concludes. So, oh yeah, you should also be able to access it through the panel on the side, the GoToWebinar panel. I think they're available in there as well. And without further ado, I will let Michelle take over.
Good afternoon. So we'll begin with an overview of OCIs, and we'll start with an introduction to organizational conflicts of interest, which we'll be referring to OCIs throughout the presentation. There's three types of OCIs: unequal access to information, bias ground rules, and impaired objectivity. We'll be walking through what the definition of each of those and different examples, and then how you could try to mitigate those OCIs. Then we'll discuss waiving an OCI, strategic considerations with respect to OCIs, which includes when you're preparing your proposal and when you're either filing or defending a protest. And then at the end, we should have some time for questions. So the FAR defines an OCI as arising when, because of other relationships or circumstances, a contractor may be able or potentially unable to render impartial advice or assistance to the government. The contractor's objectivity in performing the contract is or might be impaired, and/or the contractor might have an unfair competitive advantage. Now here it's important to understand that it's not just the prime contractor that may have an OCI. It could be a team member, subcontractor, or it can even be some employees within the contractor or the subcontractor. And as I said, there are three types of OCIs. They're listed there. And you should know that an OCI analysis is complex. Contracting officers are required to identify and investigate OCIs as early in a procurement as possible, even before an RFP is issued. And assessing an OCI is a fact-specific inquiry that depends on the requirements of the contracts at issue and the experience of the contractor. OCIs are dynamic because, as you know from your experience, contracts can change and relationships within an agency can change, and many OCIs can be mitigated, neutralized, or avoided.
Yeah, it's just important to note, like Michelle said, when you're talking about OCIs and identifying OCIs, the onus is really on the government personnel, not on the contractor. Now, a lot of times the government will put requirements in the RFP, making the contractor certify as to whether or not they have an OCI or known or potential OCI, and that's perfectly fine. That's a good way for the CO to sort of lighten their load a little bit, or to get input from the contractors so that they know where to look. But it is the contracting officer's responsibility primarily to determine whether an OCI exists and what to do about it, which necessitates a lot of times conversations with contractors. And normally there tends to be a blackout with contractors, but when you're talking about an OCI, we see it quite often where contracting officers will speak to potential offerors or people who they know are going to bid who might have OCIs, not about any of the substance of the proposal or the RFP, obviously, but about specifically what sort of relationships exist and how or if the companies plan to mitigate and how they plan to mitigate. Because like the FAR requires, they need to get out in front of it as soon as possible. So that's one of the ways that they do that. So it's just a good thing to remember, everyone, government individuals who are out there, and also for contractors to know that.
We'll move on to the next slide. Now, the significance of OCIs is an important thing to consider. They are a growing problem. This happens with industry consolidation, fewer companies performing different kinds of work. The government buying services that require the exercise of judgment, for example, helping to evaluate programs requires a lot of judgment in most circumstances, and then the use of umbrella contracts. They're also significant because contractors can be excluded from procurements. As we said, the FAR requires COs to identify and evaluate potential OCIs as early as possible and to avoid, neutralize, or mitigate them. This has resulted in a trend of government utilizing blanket approaches and telling contractors that they're precluded from a whole category of procurements within an agency. OCIs are also significant because of a protest risk. It could happen before or after award, as we'll talk about later. And OCIs can have a big impact on your business. A lot of big companies have restructured or spun off entities to try to avoid OCIs. Can also affect whether you select a subcontractor or a team member and what opportunities you're able to compete against, and can cause inefficiencies and increased costs when you have to mitigate a potential OCI.
Yeah, just like to note also, we've seen, as far as corporate restructuring and things like that, we've seen it with a lot of our smaller business clients as well, because this is an issue that can strike people really hard, especially if a company has one line of business and it starts to go down another path, seeing a lucrative opportunity, and it turns out that the lucrative opportunity has now conflicted them out of the work that they did previously. And so what we've done or helped clients do before is to set up subsidiaries or spin off parts of themselves. And even if you're a small business, in most cases, the 8A program is a little different, but in most cases, you're allowed to have subsidiaries that can do certain work. Now, of course, if it's the same owners and everything, the two companies would be affiliated. But if they were one and the same before, that's not a real issue. And there are certain things you'd want to do in order to mitigate OCIs. And we'll go through that as well. But I'd like to also note, when we're talking about protest risk and the trend of the government utilizing the blanket approach, those two things can go hand in hand, because like Michelle noted, a lot of times the government is they're taking the stance, and I believe this is probably to ease some of the burden or kind of shift the burden of OCIs, but they're stating, look, we're going to put this procurement on the street. It's going to have 4 different parts, or 4 different tracks, if you will. If you win track 1 and track 2, you are conflicted out of track 3 and 4. Or if you have the prior issued contract A and B, then on this procurement for contract C, if you have A or B, you can't bid on C. That view, or that sort of blanket approach of automatically determining that a certain contractor has an immitigable OCI based upon what other contracts it currently holds, is completely antithetical to the purpose behind OCIs in the FAR. And so really everything has to be viewed in a fact-specific inquiry and fact-specific fashion. And so to take an approach based just merely on generalities is inappropriate. And so if you see something like that in a procurement and you want to bid on it, you believe you might have an OCI or potential OCI, but you believe it's mitigable, and the government is stating in its RFP that you're not even getting a chance to mitigate because they're making certain assumptions that the OCI is immitigable. That is something you might want to think about protesting prior to the submission of bids, or maybe a gentler approach would be to raise the issue with the contracting officer, and to avoid having to go through the expense of a protest. And frankly, you don't want to give the agency a black eye or anything like that. So just to raise the issue and see if they think about removing the requirement or revising the RFP to make it a little less stringent. So just something to think about.
Okay, the first type of OCI that we're going to talk about is unequal access to information. This happens when a contractor has access to competitively useful non-public information through the performance of a contract. For instance, maybe you're working within an agency and you're giving input into an RFP that's going to come out. So you have access to that proprietary and for that competitively useful information that other companies don't have access to. Or maybe as part of a contract, you get to see other contractors' costs and labor information. In that case, you'd have access to proprietary information, which could cause an OCI. Now, incumbency is generally not an unequal access to information OCI. There can be times when, because I said you have a contract, you're getting access to that information. But in most cases, just straight up incumbency is insufficient. So here we have a couple of examples from protests at the GAO and the Court of Federal Claims in the last few years where they are found unequal access to information OCIs. So in Netstar Consulting, while performing a support services contract, the company had access to an agency network that had budget information about contracts, including labor categories, rates, estimated number of employee hours, and funding. So basically, it had access to all of its competitors' pricing information. When it won the contract, there was a protest, and that protest was sustained because that company definitely had access to competitively useful non-public information. Similarly, in L3 services at the GAO, Company A had teamed with Company B to provide procurement support services to an agency. This was multi-step procurement, so that was phase one. And then Company C proposed Company A as a subcontractor for phase two. And the GAO held that an OCI existed because Company A had access to contracts, core requirements, information of other companies, and non-public information relevant to the agency activity. So those are two examples to help show what an unequal access to information OCI is.
And one other point is that in the past, I've seen it come up where contractors have lost a bid and they want to file a protest. And part of the protest is that a competitor of theirs may have gotten information about their company, proprietary information about the potential protester, through some sort of, I don't know, even commercial espionage or for lack of a better term, or something like that, or an employee leaves, or in one case, it was a satellite communications contract, and there's only a few companies that actually have communications satellites in orbit, and so, which obviously it's very expensive, and so you have to go through those companies and lease bandwidth from those companies' communication satellites, and therefore those companies know what everyone else is paying for the services on their communications network because they're the ones providing it. And so when those companies are also your competitors, obviously they have information about what your pricing buildup is because they know what your costs are. And I've seen that try to be raised a couple times. And the general rule is that if the information that stems or where the OCI is stemming from, it comes from an independent source and not from the government and not through a federal contract, it is not an organizational conflict of interest as defined under the FAR. It might be some other civil violation. The company, in the case of, say, espionage or something, they might have violated the Trade Secrets Act, or if one of your employees took information, that employee might be violating a non-compete provision or a non-disclosure agreement or something to that effect, and you might be able to take action against the company or the employee directly, but it's not something that you can use as the basis of an OCI and a protest or any other action against the government. So just important to keep that in mind.
And also know that if you bring that kind of dispute to the GAO or Court of Federal Claims, they're usually not going to get involved in a dispute between private parties like that. So an unequal access to information OCI is the easiest type of OCI to mitigate, and usually you do not need to have any assistance from the government. The idea here is to focus on limiting access to competitively useful information. This needs to be proactive and forward-looking. So as soon as you start performing that contract, or before you start performing that contract, where you know you're going to have access to competitively useful information, you put the steps into place. You implement firewalls. You have personnel who are working on that contract sign non-disclosure agreements or NDAs. You can locate personnel in separate spaces and facilities so that, that water cooler talk does not become a problem. Document control measures employee training so that employees understand the risks posed here and why it's important to comply with the steps that you're implementing. And one way that agencies can use down the line to mitigate an OCI of this variety is to release all information to all competitors so that one offeror doesn't have the access that nobody else has.
Yeah, the other issue here too is that when you're talking about getting out in front of things and making sure your employees aren't going to speak to each other, the so-called water cooler talk and things like that, is if you have the non-disclosure agreements in place and you have training in place to tell your employees not to communicate with each other about certain information, and the company itself is taking steps, and there's no specific evidence showing that the employees have spoken to each other, then generally the existence of the training, the existence of the non-disclosure agreements is sufficient unless there's reason to doubt it. So I know people have asked before, well, I can't necessarily monitor Joe and Sally when they're, going out or having a drink or something. That's not necessarily as far as you have to go, although your employees should understand that should something be discovered, that can cause serious detriment to the company and could result in their termination. So just something to know. I know it just comes up a lot where people ask the question about how exactly are you supposed to police these sorts of things.
Okay, the second kind of OCI that we're going to talk about is a bias ground rules OCI. And this occurs when a contractor prepares the specifications or work statements or other types of solicitation documents. The concern here is that a contractor would shape the requirements in its favor, even if inadvertently. And this could be any document that influences proposals and how they're going to be evaluated. Even white papers and studies can give rise to a bias ground rules OCI. And that's an example here in Energy Systems Group, a GAO protest, where the protester was a subcontractor on a contract that helped prepare recommendations on how to conserve energy. And the agency then used that report to help develop the requirements for this solicitation. And 80% of the requirements in that solicitation came from the study. So the agency told that company, you're excluded, you cannot compete for this. And the agency protested, and GAO denied the protest because it was reasonable to exclude that company.
We just had a question about whether or not input into the creation of the independent government estimate would fall under sort of bias ground rules or could create a bias ground rules OCI. That it could, I would say generally though, it would fall under the unequal access to information realm, where if you are creating the IGCE or you have some sort of input into knowing why the independent estimate is what it is, that gives you insight into the procurement that other offerors would not have. And so that's really the risk that I would see. And the good news about something like that, though, is that, as we noted, it's easily mitigable. And as long as you have something in place during the first contract where you're having input into the government estimate, if during that contract you have firewalls set up, the non-disclosures and all that sort of things, then before you go start putting the proposal together for the new contract, you firewall those employees. You keep them physically separated to the extent you can, and all the items that we noted, that would be ideal. And then when you're preparing the proposal where the independent government estimate information could be useful, you sequester those people to the extent you can, or at least when you're having the proposal meetings, proposal drafting, any sort of discussions about how your pricing should be put together, that those individuals do so behind closed doors, and that there's some controls over who comes in and out of that room. In a perfect world, you would have some sort of notations as to who's at the meeting and things like that, so that if something comes up in the future, you could not only show you have the non-disclosure and that the employees have been trained not to speak about it, but you also have proof that during the meetings where the pricing information on the proposal or other issues on the proposal that could be touched by the independent government estimate, that those were done behind closed doors, and that there was no input from the team or the personnel who helped work with the IGCE. So that's a good question.
And that transitions smoothly to our next slide, which is mitigation for bias ground rules, OCIs. And these are more difficult to mitigate than an unequal access to information, OCI. And that's because here you have a conflict based on your affiliation with an organization or an economic interest. The employees of the contractor, even if unintentionally, will be thinking of what's best for my boss, what's best for my company, and potentially skew things in that favor. Firewalls are ineffective to prevent that from happening. And using a separate division or entity is also insufficient because if you're sister companies, you could still want to help the other company. That's why you likely need government participation in the mitigation efforts. So 2 possible ways to help mitigate these are recusal, and that's most effective possible in a multiple award contract scenario where there's lots of task orders coming out and you could segregate the type of work you're going to be doing and identify those efforts in advance, or using a combination of employee firewalls, NDAs, and a subcontractor so you can separate out the work that could be conflicted.
And just to go through a couple of quick questions again, somebody asked, what should a company be careful of when using when a U.S. government client asks them and their employees to sign an NDA? Usually that's a scenario where you're falling again under the unequal access to information, where the most common time I've seen it is where you're going to have some access to proposals or like performance information of another contractor, and so they want to make sure that or that other contractor, frankly, and the government wants to make sure that their information is being protected. So they force you to sign an NDA. Now, when you're signing the NDA, there's not a whole lot to worry about there, except you don't want it to be overly restrictive. You want it to be limited to the information you're getting that might be proprietary or trade secret information of your competitor. It shouldn't necessarily be any information you're getting access to. So I'd say the NDA should be limited, and in addition to the NDA being limited, the fact that you're signing an NDA is a pretty good indication that you're falling into a unequal access to information OCI. And so before you even start that contract, or as soon as you find out what exactly you're going to be doing and that an NDA is required, I would recommend putting a mitigation plan in place so that you're firewalling your people, you are, aside from the NDA to the outside world, which I think is what you're talking about. So the NDA between your company and your employees and the government, or your company and your employees and the other contractors whose information you're reviewing, that's one thing. But you want to, in addition to that, have the NDA between you and your employees. So you need actually two NDAs in that situation, one for external, one for internal. Because if you have the external but you don't have the internal, then your employees could, in theory, be sharing information with each other, and that potential organizational conflict of interest, the unequal access to information, could permeate your company and conflict you out of a lot of other awards. So it's just something to keep in mind.
And I would add that you may want to run that NDA, that if you develop one, by the CO and by your counsel, to make sure that it's going to work, because it would be very unfortunate if you went through all those steps and then 2 years down the line were conflicted out of competing. We also got a question about whether input into the development of like reports, as I mentioned, that go into a RFP, why that would cause a conflict. And the idea there is that even if you're not directly saying this is what a strength should be, this should be a mandatory requirement, that you're still influencing and shaping overall requirements. For instance, in that energy context, if you were saying biofuels and solar are great ways to conserve energy, and your company was really, really good at those things, putting those in as plus factors or aspects that should be in the performance of work statement would benefit your company and potentially to the detriment of your competitors. Okay, here's our third type of OCI, impaired objectivity. And this happens when a contractor is evaluating either its own work or its competitors. And obviously here the problem is that you could potentially be biased in your favor or biased against your competitors. So here we have two examples of protests from the GAO. In Purvis Systems, the successful offeror, this is actually Northrop Grumman, would be providing analytical and technical support services to assess undersea and warfare systems. And the agency awarded the contract to Northrop Grumman. And Northrop manufactured 12 of the 59 systems that were going to be tested, and then the remaining systems were manufactured by its main competitors like Lockheed Martin and whatnot. So here GAO sustained the protest because the contractor would be evaluating its products and the products of its competitors. Similarly, in Nortel Government Solution, the government was looking for a contractor that would provide consolidated IT operations and maintenance services, including making recommendations about existing programs. Company A had a contract to provide the agency's desktop environment, and the agency selected that company for award. GA held that that company had an OCI because it would need to make recommendations about its own product, its desktop environment services.
Yeah, and I've seen it similar to the Purvis case, where you see cases where a company might be doing, say, certain IV&V or something like that, evaluating a number of different items, or looking at other proposals or preparing certain proposal information that then goes into how people are evaluated. And in those sorts of cases, like this, they might be evaluating, say, 12 of 59, right? And for those 12 items out of the 59, it might be possible, if you work with the government ahead of time, to get them to agree to some sort of mitigation effort, such that for those 12, or as soon as something comes up and you know that you're going to be evaluating your own work, or the work, or one of your subcontractors is going to be evaluating your work, or something like that. Anything where an impaired objectivity potential OCI would come up, so long as if you've informed the government ahead of time and worked with them, there might be a way to shift that work to another contractor in the MAC context. So another prime contractor would take over those particular ones, and it could be a seamless shift if you have multiple contractors doing the same general type of work and just splitting the systems, in this case, up. You can just shift them back and forth. Or another possibility would be to put in a subcontractor, but in that case, the subcontractor would have to not know that the people they're evaluating would be their prime, because otherwise there's an idea that they know where their bread is getting buttered, so to speak, and they could um, evaluate the prime contractor's work unfairly to give them higher ratings than they otherwise deserve in order to as a sort of a kickback, so to speak. And so these are definitely things that have come up. And if you work with the government early, you can mitigate these issues so long as the government agrees. And I think, as Michelle noted, it's really up to the government discretion as to whether or not they want to give you that kind of assistance. So it's not something that's really a protestable issue if they refuse to help you. It's just if you have a good relationship with the contracting officers or with the government, you can benefit from the government being willing to help you and willing to work with you to help mitigate some of these OCIs.
Which transitions once again into our next slide on mitigating impaired objectivity OCIs. As we mentioned, they're extremely difficult to mitigate. Once again, we're looking at your affiliation with your organization, and your economic interests. So that for the same reasons as the previous type of OCI, firewalls are ineffective, using a separate division or entity is insufficient, and any knowledge or potential knowledge of the entity being evaluated is likely to trigger immitigability. So here, as I mentioned, you could potentially use a subcontractor or a neutral third party if possible, and this requires a lot of government cooperation, to use objective criteria where you wouldn't be able to have any bias because there'd be standards. Either you had the right amount of output or you didn't. You either performed and met the threshold or you didn't. And government supervision and control are necessary to obscure the identity of the evaluated entity and elimination of identifying information.
Yeah, and at the end here, we're saying this is why you see more procurements that limit contractor identifiable information. And what we're getting at there is just, in our experience, it's come up a number of times recently, where the procurement itself, and clients have called and asked, there's a strange requirement in this procurement that I can't say who I am, and I have to be careful as to how much information I say about myself in whatever section it is, the past performance or the technical, where I have to limit that information so that no one can tell it's me. But how am I supposed to do that whenever it's important that I fully explain my technical approach and I fully explain my experience to have the best chance at receiving an award, and in doing so, say I'm the only one who has done X, Y, and Z, and so it's going to be clear who's proposing here. And that's something that has become a more difficult issue as of late, because I think this goes together with what we said earlier, where the government is taking a blanket approach and saying, if you've performed work on these couple prior contracts, you're prohibited from bidding on this later contract, because they're saying we don't see any way to mitigate the OCI, so we're making a blanket supposition or whatever. We're assuming that there's OCIs that are immitigable if you've performed work on those prior contracts. And like we said, that's improper. Similarly, it seems like the government is trying to force contractors to help them to avoid OCIs. And this might be part of the mitigation plan that they put in place for the contractor that's helping them in the evaluation effort. So if there's a contractor evaluating the proposals and another division or a subsidiary of that company is bidding on the work that they're actually evaluating, part of the mitigation effort might be, if the government were to agree, they could put in the proposal that all contractors need to sanitize their proposal so no one knows who they are. Who knows if that actually occurred in the particular circumstance I'm thinking of, or circumstances I'm thinking of, but it's just something we've seen more often, that it seems to me goes to the general trend of trying to make it easier for the government to avoid having to do a full OCI analysis, which frankly makes sense because a lot of the agencies are understaffed and they don't have the personnel to push through the number of procurements necessary. And so they're trying to find ways to streamline the process. And unfortunately, some of the FAR provisions don't necessarily allow for that kind of thing. But that's what we're talking about there. And it's just something to be aware of, because I haven't seen a protest on it yet. But if it was something where you believe that it really impaired you and that your incumbency was critical and that you can't talk about it, that might be, if the government's trying to restrict you from using your name and things like that, that might be an improper restriction or something that's unduly restrictive of competition.
Okay, now we're going to move on to the next topic, which is waiving an OCI. And the FAR provision relevant to this is 9.503. I won't read through it for you, but the idea here is that the agency can basically waive an OCI whenever it decides it would be in the government's interest, which is a very broad standard. If you were listening on to our last webinar on terminations for convenience, you might know something about the government interest and how broadly that can be construed. So the only limit here is that the agency head has to do the waiver. And this can come up in the context of a protest. So here we have some notes about MCR Federal, a GAO protest. And here the CIA had issued a solicitation for cost analysis and research support services. And the RFP warned offerers that the awardee would be unable to participate in intelligence community agency acquisitions for major systems for the life of the contract. And also, any contractors who are currently providing systems engineering and technical assistance support to prime or subcontractors would be excluded from the procurement. And after those restrictions, with those in mind, CIA made an award to a company with a current contract, and that was protested. The CIA opted to waive the OCI, and the GAO denied the protest, then stating that where procurement decisions such as whether an OCI should be waived is committed by statute or regulation to the discretion of agency officials, our office will not make an independent determination of the matter. So that shows you that GAO is probably not going to get involved in questioning whether the agency should have waived the OCI. And SRA International is similar in that here the GSA awarded a task order to a company, and SRA felt that company had an OCI, and it protested. Late in the protest process, the 91st day, now remember, GAO is required to make a decision by the 100th day. So this is basically the last week of the protest. GSA notifies GAO that it waived the OCI. So GAO dismissed the protest. SRA challenged the waiver at the Court of Federal Claims. The Court of Federal Claims asked the GAO, do you think this waiver was okay? Was it consistent with the Administrative Procedures Act? And GAO responded that the waiver complied with the APA. So SRA International lost. As a side note, the Federal Circuit later held that the Court of Federal Claims shouldn't have heard the case anyway because it was a task order and not within the court's jurisdiction. So there still is somewhat of an open question of whether if you had a protest within the court's jurisdiction, you could challenge the waiver at the Court of Federal Claims. And now we're getting into where the rubber meets the road here, strategic considerations when you're preparing your proposal. So when you first get the solicitation, you may notice some provisions relevant to OCIs. You may be directed outright to submit a mitigation plan. The contracting officer could say that everyone needs to do that. It could say there are some reasons why we think there's an OCI here. If you think there's an OCI, please submit a mitigation plan. And the solicitation may also advise you of restrictions on future activity. Like if you're awarded this contract, you're going to be precluded from other work with this agency in these areas in the future. So once you see those provisions, you need to start making some decisions. If you think you have an OCI, in many cases, it'll be good to get out in front. If you can avoid, neutralize, or mitigate that potential OCI, you should do so as early as you can. If you understate or hide that potential OCI, you impose risks that you could be excluded down the road, or even after award, there could be a protest. You end up spending a lot of money on an opportunity that you're conflicted out of because you haven't worked with the agency on it. And you can also, as Sai has been saying, work with the government to try to address these questions in, socialize these issues with the contracting officer. So here's some ways to address the issue. You can submit a mitigation plan. The agency can communicate with you during the proposal process about whether your mitigation plan is adequate, whether you have an OCI, without engaging in what's known as discussions under FAR Part 15. That means the agency is not required to go talk to every offeror about OCIs. If you're the only one with a problem, it can just limit those conversations, we'll call them, to you. And you can also address the OCI directly in your proposal if you're confident about your mitigation approach. And then Cy will talk about whether there's any time you should avoid discussion.
Yeah, and just to go back kind of quickly to kind of pre-proposal discussions or conversations with the government or with contracting officers, the way this normally comes up is a contractor who does a lot of work for a particular client, a particular agency, and then they start showing up for industry days, for a new procurement, and the contracting officer or specialist or the COTAR, whoever it happens to be, recognizes the representatives of the company, knows that they have work on prior contracts, and believes that because of the work on those prior contracts, there might be some OCI issues. And so I've definitely seen that happen a number of occasions where the contracting officer or the specialist approaches the company personnel and says, hey, what are you guys doing here? Because you've got contract A, and contract A is really going to conflict you from bidding on this. And when that happens, clients can be taken aback, or contractors can be taken aback, or either confused or kind of worried, especially if the individuals you have at the industry day are not maybe your C-suite or your higher level employees. If they're some of your BD people or some of your program managers, something like that, at the industry day, they might be concerned. Conversations like that might have them concerned about their jobs if they think there's some conflict. And so, what you really want to do in those circumstances is, once something comes up, contact the individual who raised the concern and get more detail about specifically why they believe that there might be an OCI, and like Michelle was saying, socialize with them the possibility of giving them a mitigation plan or submitting something to them in writing. You could try to have a meeting, but a lot of times they're going to want something in writing to show them why you believe that any potential OCI either is mitigated or it doesn't exist to begin with, as a way to just get out in front of things. And so I've seen that a number of occasions, and most of the time it works if it's explained clearly enough. And if it doesn't, and you really think you have a mitigable OCI and the agency is not recognizing it, then there's always the potential of protesting. Now, I think we might get into this a little bit later, but remember that there's timing issues for when you protest. So I think we'll talk about that in a minute. Just to go to, I think, a couple questions really quickly as well. If the U.S. government, an individual asked, what if the U.S. government doesn't do a good job in making documentation, marking documentation rather, as competition sensitive, and you mistakenly disclose information? How can you protect yourself? First of all, if the government is releasing information that's source selection sensitive or competition sensitive or proprietary of another contractor, first and foremost, that's the government's problem because it's a potential Procurement Integrity Act violation, and that should never have occurred. And the government personnel, if it's a contracting officer or otherwise, there could be repercussions for that individual personally. However, for you as the contractor, what we normally recommend is, if it's something that has gone to everyone. For instance, I was working with a client recently, and they called me and they said, we just got our competitor, the government just sent us the entire proposal of a competitor, and it looks like every single person who is a potential bidder is copied on the email. And I was like, as soon as they told me that, I was like, just delete it, certify that you've deleted it, that you didn't look at it. It's just not worth the headache, because if you look at it and you go through it or you download it and a question comes up, it could happen that if there's some investigation or someone who protests you and it comes out that you did download it or you did look at it, then you, even if you're the awardee, you could lose the contract. So the best course of action is just to say, well, that was a Procurement Integrity Act violation, but I'm not going to get caught up in any OCI issues, or I'm not going to get caught up in any problematic Trade Secrets Act or anything else issues. I'm just going to delete this. I'm going to certify it's gone. I didn't look at it. Done. However, if it's not clear, if you're sent a document and you're not sure if it's competition sensitive, and a reasonable person would say it's ambiguous as to whether or not it's competition sensitive, and you release it in that sort of context, if the government sent it to you, if it does give you unequal access to information and it was through the government's release of information, it could still be a problem for you. But there's definitely arguments as to why it would be inequitable to disqualify you. And in that sort of context, it might make sense to release that information to all offerors, to kind of try to release everything and even the playing field. That's probably the best way to handle that. If that's not possible, then it's unfortunate, but the government could try to make you sort of a sacrificial lamb to continue to make sure that the procurement doesn't have to get canceled, because that's always the other option, is cancel the procurement, change it a little bit so that the information that was released is no longer relevant or helpful, re-release it, new proposals, you got to start from scratch.
Another attendee asked if a small business can realistically mitigate an OCI. And we'll say, OCIs are fact specific. So depending on the type of OCI, it's easier or more difficult to mitigate it. But we've definitely helped clients of all sizes mitigate an OCI. Even if you're a small company, you can set up password protection for documents. You can have non-disclosure agreements. And train your employees. So it's still worth considering and, investigating the different opportunities and different facts behind each procurement. Oh, and then we have another question of why doesn't the government provide mitigation strategies? And at the end of this presentation, we'll actually tell you about a proposed OCI rule change that came out about 4 years ago. And in those rules, they actually have some proposed mitigation strategies. Why the government isn't doing it now, as Sai said, they tend to put the burden on contractors, unfortunately. And also, in their defense, the contractor is more familiar with its business, its operations, its org chart, its facilities, its IT systems to know what kind of things are possible and what kind of things are not.
Yeah, and the onus on the government is to identify the potential or actual OCIs and to see whether or not the contractor has mitigated those, or to ask the question at least. It's not to necessarily help in mitigation. It would be, as far as the FAR is concerned, or the government's concerned, if you identify an OCI and you just say, okay, you have an OCI, you're disqualified. That's the end of the analysis from the FAR's perspective, and it's up to you to essentially argue why you have mitigated it, and then the CO reviews that and makes the final determination. But it's not the government's responsibility to help you mitigate the OCI. Now, as Michelle noted, the new rule seems to it does help contractors a little bit, which makes sense, because if you help people mitigate, you increase competition, and therefore the whole purpose behind the Competition and Contracting Act and our whole federal procurement process is furthered by helping people mitigate and increasing competition. So it would make sense to do the assistance, but we're operating in an environment where there are fewer and fewer federal personnel in these procurement jobs, especially at the contracting officer level and some of the higher levels. And so I think it's a time constraint issue, which kind of goes into what we were saying before.
Okay, so the other area of strategic considerations has to do with proposals. No, I'm sorry, we need to move on to the next slide. Okay, protest. So as Cy mentioned, there are timing considerations here. So when to protest? If you believe another offeror or its team member, its subcontractor, whatnot, has an OCI, and you know the concern has been raised to the agency, perhaps at an industry day or in written Q&A, and you know or emails that you've had with the agency or discussions you've had with the agency, and you know the agency is allowing the offer to compete, you must protest before proposals are due. If you know that the agency is allowing this offer to compete and you wait until that offeror is selected for award and you protest, you're going to be dismissed as untimely in 99% of cases. Similarly, if an agency excludes you because of potential OCI, you must protest before proposals are due. And you should protest before proposals are due if there's a harmful blanket prohibition on bidding based upon perceived OCIs. Now, in that circumstance, you're probably going to want to protest well before proposals are due, because when you file a pre-award protest to preserve your right, you need to also submit your proposal. So you don't want to go down the road of preparing a proposal, expending all that time and resources, waiting until proposals are due, and then filing your protest and filing your proposal, and then finding out you're going to be excluded no matter what you do with the OCI. If you try to socialize that OCI issue early or protest that OCI issue early, you'll know whether you need to go through that whole proposal exercise. Once a protest is filed, the standard of review comes into play. Now, the responsibility of identifying an OCI and whether exclusion is warranted rests with the CO, and the CO is given considerable discretion. To succeed in a protest, if you're alleging that an OCI exists, you must identify hard facts that indicate the existence or potential existence of an OCI. You cannot just have inference or suspicion that there's an OCI. You can't just say, I heard that company X is performing this kind of contract and therefore there's an OCI. You need to have some concrete evidence that there is a problem. And hear a little bit more about the standard of review. The GAO or the Court of Federal Claims review reasonableness of the investigation and whether the agency gave meaningful consideration to the issue. They're not going to undertake their own OCI analysis. They're going to look at what the agency did and whether it was reasonable or not. Once again, the agency is getting a lot of discretion here. And then, as I said, the GAO and the court are not going to submit their judgment for the agency unless there's clear evidence that the agency's conclusions were unreasonable. And that does happen. Sometimes the agencies accept a mitigation plan that on its face is not going to work. And then you can get a sustained protest. If you happen to be the contractor defending the protest or actually intervening and helping the agency defend the protest, you want to be able to show that your mitigation measures are sufficient, that the agency did a thorough investigation, and that there are no hard facts there.
Yeah, and also if you are on the receiving end of, or the agency excludes you, so you're on the receiving end of an agency exclusion letter based upon an OCI issue, and you want to protest that determination. We've had some success if your mitigation plan, clearly indicates that the agency is missing something, or if they didn't in their exclusion document or in their rationale for excluding from the competition, they didn't clearly state why the mitigation plan you put in place was ineffective, then you might have some success there in protesting your exclusion. And hopefully that comes up in a competitive range type determination. Then you can get in there relatively quickly. The agency might take corrective action. You get back into the competition. Otherwise, if you're stuck in a long drag out protest process and the procurement keeps going forward, they can't make an award to anyone, but they can continue the evaluations, which can create a situation where you get further and further behind. And even if you win, you might be rushed into providing whatever additional information the agency might want, or going through some sort of FPR where you're not as prepared as other offerors potentially. who have been in the process the entire time. So again, even if you have a viable protest on the defense side, it makes more sense to get out in front of these issues and to socialize it with the government, whether it's a contracting officer, whomever, as soon as possible. And I know in an earlier slide we said, when do you sort of not want to talk to the government? When do you want to keep things under wraps? And I would say the only time I would ever do that is if you have a really bad OCI, you don't think there's really an effective way to mitigate it, but you feel like it's sort of below the radar and you just want to keep your head down. That's really the only time, and that's sort of a non-legal answer to things. But usually we recommend that clients get out in front of it and have a mitigation plan in place as soon as possible in order to mitigate these sorts of issues. Oh, and someone asked about protests, whether or not if you are protested, if you're the awardee and you are protested based on an OCI concern, does the government have to notify you of the protest? And the answer is yes. They have to send you a notice of the protest and give you an opportunity to intervene and respond to the protest.
And you'll get a redacted version of that protest.
Right. If you, the company, will get a redacted version of the protest, and if you have counsel, they will be able to see, and they get under the protective order, they will be able to see an unredacted version of the protest, which anytime you have won and you're intervening, or you might want to intervene in a protest, we generally recommend doing so and hiring counsel, whoever that might be, because you control the costs whenever you're intervening. Frankly, you don't have to file anything if you don't want to. You can just get somebody who's on your side to look at the documents and spend an hour here and an hour there, and all in, they spend 4 hours on a protest, and that's it. So you can really, or less, you can really control costs there, and I would think it's to your benefit, just in case you're being directly attacked or something, and you personally, the company, can't see that information because there's some sort of redaction. And that is especially true in the OCI context, because if they're protesting you on an OCI basis, they are directly attacking you and directly attacking what you can do.
And on a similar line, depending on the agency, they may be short-staffed, and often they will reach out to interveners counsel for assistance in responding to arguments. And especially with an OCI, you, the company that mitigated the OCI, has the facts and the relevant information. You have more information than the government has, so you can raise a better defense than the government would on its own. So we also have a question about a reasonable time frame to submit a mitigation plan. Once again, because OCIs are so fact-specific, that can really vary. I'm currently working on a protest where offers were given 2 days, 1 business day actually, and over the weekend to develop a mitigation plan. That may actually be sufficient for a really simple contract, but if you had a very complicated contract, it could take several weeks to develop a very thorough mitigation plan, especially if you need to implement those measures in advance. So you have a few minutes left to get to our final topic in the presentation, which is a pending proposed rule. This was proposed in April 2011. It's kind of strange that it hasn't been issued yet, but these things happen sometimes. The rule would recategorize OCIs. They would move them to FAR Part 3, improper business practices and personal conflicts of interest. And the rule would distinguish between OCIs that create an unfair competitive advantage and OCIs that impact the government's interest by compromising contractors' objectivity. COs would have a greater discretion to address and accept the risk posed by that second kind, the compromising of objectivity. The amended rule would also create some new contract provisions and solicitation provisions. Offers would have to certify they're providing all the information, relevant information, including information about potential subcontractors. And when you signed your offer, you would be making a formal representation of compliance with disclosure requirements, which has ramifications for potential False Claims Act liability and things like that. The CO would also have an increased requirement to seek out information. There'd be a new subpart 4.4 for safeguarding information, and that's where these unequal access to information OCIs would go. And there would be standard specific provisions for treatment of affiliates, where COs would be required to analyze the business relationships between an offeror and its affiliates using a list of factors, and that the rule would identify structural or behavioral barriers to lessen the risk posed by an affiliate. So those are those mitigation measures that we mentioned will be listed in a rule.
Yeah, and just we have one last question about is there a requirement for the government to specify evaluation criteria that they would use to determine a proposed OCI mitigation plan as to whether or not it's acceptable? There really is no requirement for something like that because they are the evaluations of an OCI and whether it's been mitigated are supposed to be very, very fact specific, and therefore the factors that you would evaluate in any situation are specific to that situation. Now, there might be some general issues like we went over earlier, but depending on the facts on the ground, it's going to change. So even if multiple offerors are bidding on the same procurement, how or what would make sense as far as mitigation techniques for each of those offerors could differ greatly depending on their size, how many locations they have, how their personnel are structured, all those sorts of things. So unfortunately, there is nothing like that exists because it is just a fact-specific inquiry, which kind of goes back to why what the government's doing or what we've seen the government do now in some cases about making blanket prohibitions and things like that is just improper because you can't look at OCIs in a generic or general fashion. It's always specific. And with that, thank you for attending. I think we got through all the questions, but if anyone else has any other questions or if they want to walk through anything or any issues, just feel free to give us a call or send us an email. Our contact information is right there. Also, these slides will be available on our website if they're not already, and this will be posted to YouTube fairly soon, and you guys can revisit this lovely webinar anytime you want and share it with your children. So thank you very much and have a lovely day.